So as you were just notified, this webinar is being recorded and I will share more on that momentarily. But I am really pleased to present this month's Mid-Atlantic Planning Collaboration webinar, Implications of Recent Clean Water Act Decision on Land Use Planning. And we have with us today our friends from the Land Use and Sustainable Development Law Clinic at the West Virginia University College of Law, Jesse Richardson and Jared Anderson. As you'll notice, this webinar has been approved for law credit as well. So I will be putting the CM number in the chat momentarily, along with the link to our YouTube page where you can find all previously recorded webinars in the series, and this one will be up there in just a few days. We really do encourage questions, but please submit your questions through the Q&A box versus the chat box. This will just help our speakers keep track of all inquiries. You can use the chat box to feel free to message me if you have any logistical questions. And also during the more formal Q&A portion towards the end, you can use the raise hand feature to request to be unmuted if you'd prefer to ask your question out loud. But again, I'm going to hand it over to Jesse Richardson, who will be presenting most of this webinar today. But keep your eyes peeled on the chat box where I will be dropping all the helpful information for this webinar and also for the Mid-Atlantic Planning Collaboration in general, and also maybe a few APA Virginia conference plugs. Thanks everybody for joining, and I will now pass it over to Jesse.
Thank you, Jillian, and I'm happy to be here this afternoon. Thank you for coming. I'm going to be talking about the Sackett decision, and also another decision that was in 2020 impacting the Clean Water Act. But there's been a lot of discussion lately, not only among planners and lawyers and environmentalists, but it seems like everybody has been talking about the Clean Water Act, and specifically waters of the United States and which wetlands are waters of the United States and which wetlands are not. Excuse me, I guess I should have introduced myself first. I'm Jesse Richardson, the lead land use attorney with the Land Use and Sustainable Development Law Clinic at West Virginia University College of Law, and I'm a professor at the College of Law as well. My colleague Jared Anderson is here. He won't be doing much of the presentation. He's here if we have some really difficult questions that I can't answer. I'll turn that over to Jared. But in addition to my work with the Land Use Clinic and at West Virginia, I've been following the Clean Water Act and specifically waters of the United States for quite a while. And so I've given dozens of presentations on this. This is a little different, and I'm glad that we're going to be able to talk to planners specifically about that. And what I've been hearing is that a lot of people at the state and local level are very concerned about what the impacts of Sackett will be. I hope that this will be a little different from most of my legal presentations, and that usually I think people are pretty depressed after I'm done. But I think the message today is pretty uplifting and positive for the most part. And so I hope everybody will see by the end of the webinar today that there's actually a lot that can be done at the local level to protect wetlands and water quality. Jared and I are at the Land Use Clinic at WVU. We're one of the few land use clinics in the country. We've got 7 lawyers and 2 AICP planners on staff. We do a lot of land conservation work, but the planning part of our clinic, we do two different things really. We do education. We have our big Mountain State Land Use Academy coming up in less than 3 weeks, and we educate citizen planners and planners on various topics. And then we also work with communities across West Virginia, many of whom lack the resources to hire consultants or the like. And we help them with plans, zoning ordinances, subdivision ordinances, and all manner of land use regulation. We also have usually 10 to 12 uh, law students. They're mostly third year now that we work with in that mission. Give the standard disclaimer here that this presentation is for educational purposes, and I'm not giving legal advice, and you should not take anything I say today. Certainly talk to your local government attorney or legal advisor. I want to start, especially at the federal level. Today, most of us understand how important wetlands are, and protecting wetlands is something that we really need to do. But in 1900, the United States Supreme Court characterized wetlands as the cause of malarial and malignant fevers and opined that the police power is never more legitimately exercised than in removing such nuisances. And so early in our country, and even I'm talking into the 1900s and even into the 1950s and 60s, our farm policy, for example, was to plant fence row to fence row. And wetlands interfered with agriculture. So farmers were encouraged to plow the wetlands under. At a later time, we figured out that wetlands are very important, and I will talk about that some more. So what I'm going to do, you guys get to start off with a little constitutional law, a refresher for some of you, because I think that's important to understand the dynamic between the state government, the federal government, and local governments with respect to wetlands regulation. I'm going to talk about Section 404 of the Clean Water Act in the Sackett case. I also want to touch on the Maui County case because I think that's important as well. And then in the end, I'm going to talk about what you really want to discuss today, and that is, especially after the Sackett decision, what can state and local governments do, and in fact, what are they already doing? I want to start with the Constitution because really important with wetlands regulation. The 10th Amendment is part of the Constitution that I talk about a lot because it's so important to land use law and land use planning. And the 10th Amendment says that all of those powers that are not delegated to the United States by this Constitution, nor prohibited to it to the states, are reserved for the states or to the people respectively. What that means is that for Congress, for the United States government to have any power, they have to look to the United States Constitution. It's got to be in the Constitution for Congress to have the power. I think a lot of you in local government can sympathize with that when you talk about Dillon's rule and about of authority to local government. And so where does the federal government get the power to regulate wetlands? And I'll say that, and then say as a cautionary note that the court has pointed out on several occasions that the Clean Water Act is not a federal wetlands protection act. And that's because the authority for the Clean Water Act is from the Commerce Clause. The Commerce Clause gives Congress authority to regulate commerce among the several states and the Indian tribes. So anything that Congress does with respect to clean water has to come back to commerce. And that's really important, as we're going to see. And then let's dig into the Clean Water Act a little bit. What the Clean Water Act basically says in Section 404 is that if you want to discharge dredge or fill material into navigable waters, you need to get a permit. What does navigable waters mean? And let me back up. Why do we say navigable waters? Because Congress can only regulate if it impacts commerce. Navigable waters are a channel of commerce. That's where we start from with the Clean Water Act. Now, Congress did define navigable waters, and they did it in a way that over 50 years later, we're still trying to figure out what that means. Congress said navigable waters means waters of the United States. Well, thanks a lot. That doesn't tell us very much. So the EPA and the Corps have adopted some regulations to try to flesh that out a little bit. And so I'm going to give you the list of what the regulations say are navigable waters. And regulations can be challenged. The agency might have overstepped their authority. But first of all, and there's no controversy about this, that waters that have been used in interstate commerce or could be used in interstate commerce are navigable. Interstate waters, including interstate wetlands, are navigable waters for the purpose of the Clean Water Act. So that means if the waterway crosses state lines or the wetlands straddle state lines, it is a navigable, or it is waters of the United States, water, which is navigable waters. Now we get into a little more controversial, all other waters, including intermittent streams, which could be used by interstate or foreign travelers for recreational or other purposes. Fish can be taken from it and sold in interstate commerce, could be used for industrial purposes and the like. And my slide that should be here also says that wetlands that are adjacent to navigable waters are also navigable waters. So that language, the United States Supreme Court has tried to figure out what does that mean? And the United States Supreme Court is the final word on this. So, in a lot of the cases have focused on wetlands. Wetlands have been a real point of contention because if you look at wetlands, most of them are not navigable. Maybe none of them are navigable in the traditional sense. So we're kind of stretching the concept of navigability to bring in wetlands. In 1985, the court looked at a case where the wetland abutted a navigable water, a lake. So it was physically adjacent to the lake. And the court, in a 9-0 opinion, that wetlands that are adjacent to navigable waters have such an impact on that navigable water that they also are navigable. And what that means is that if you discharge anything into an adjacent wetland, you have to get it first. And the EPA is likely to deny that permit unless at least you do some mitigation. So 9 to nothing. Adjacent wetlands are covered. So that gives us one end of the spectrum here. Then in 2001, the court looked at the other end of the spectrum, and those are isolated waters. This was not a wetland involved in the Swank case. They were abandoned pits that had been used in a mining operation. They were now just basically pits. Those pits had filled with water, and migratory birds would cross state lines and occasionally land in these pits and use them for whatever migratory birds would use them for. So the EPA said these abandoned pits that have filled with water are navigable waters for the purposes of the Clean Water Act. And if you want to fill them in or discharge into them, you need to get a permit. The argument was that interstate travelers might cross state lines to come to these pits to, for example, take pictures of the migratory birds, or maybe to hunt the migratory birds. And when they do that, they might stop and get something to eat. They might stop and buy supplies, things like that. That implicates interstate commerce. This was a 5-4 decision. And the majority, which consisted of what we would call the conservative justices, said they were very concerned about infringing upon state and local land use authority. And they said just by the mere presence of migratory birds and the possibility, excuse me, that interstate travelers may come to these abandoned pits, that does not make them jurisdictional, does not mean that you have to get a permit. The minority, the 4 justices, said that even these isolated water bodies have a connection to not only interstate commerce, but um, to the um, to the biology and the chemical nature of clean water, and they should be included. But they were in the minority. So now we have the 2 polar opposites. If it's an adjacent wetland, it is jurisdictional, you have to get a permit. If it's isolated, has no connection physically, then you don't have to get a permit. So what happened after that was we had a lot of cases where we had a wetland that was adjacent to a non-navigable water, which ran into a ditch, which ran into another non-navigable water, and eventually made its way to a traditionally navigable waterway. And that was the situation that we had in the Rapanos 2006. And the Rapanos really the case that started us a very tortured road of trying to figure out what waters of the United States meant. In Rapanos, we had a 4-to-1 decision, so there was no majority. The plurality, because Justice Kennedy, who was the one, he agreed the case should be remanded to the lower court, and so did Justice Scalia and 3 of his colleagues. So they formed a plurality of 5. But Justice Kennedy had different reasons than Justice Scalia and his 3 colleagues. Justice Scalia said, wetlands only waters of the United States when they physically abut a navigable water. Justice Kennedy, and he was alone, Justice Kennedy said, if the water, whether it's physically connected or not, has a significant nexus to navigable waters, then it is jurisdictional. And that significant nexus depends on biological and chemical properties. It's really kind of a subjective test. It's going to have to be case by case. The 4 dissenting justices were what we would call the liberal wing of the court. And they basically said we should defer to the EPA and if they say that it's connected, and we don't need to go any further. As of 2006, we had a fractured court. We didn't really know what the law was because of some weird legal rules. Most courts were applying Justice Kennedy's significant nexus test, and the results were kind of all over the place. Then we start a regulatory roller coaster, starting with the Obama administration in 2015. Presidential administrations began to step in and say, by having their EPA promulgate rules, they said, we're going to try to clear this up. We're going to create a rule on what a water of the United States is. President Obama's administration started that in 2015. Their rule basically went with Justice Kennedy and said, if the water, wetland or other water has a significant nexus to navigable water, then it is navigable, it is subject to the Clean Water Act. Well, then President Trump got elected, and President Trump's administration said, we don't like President Obama's rule, we're going to make a new rule. And the Trump administration embarked on a process to revoke the Obama administration rule and promulgate their own rule. The Trump administration rule basically adopted Justice Scalia's opinion and said that it has to be a continuously flowing waterway to be a water of the United States, and the wetland has to physically abut that navigable water for it to be jurisdictional. And I have the little thing about lawsuits to the side, because the day after the Obama rule was passed, numerous lawsuits were filed challenging the Obama rule. The Trump administration went through, they made some mistakes. They fumbled through it a little bit, tried to revoke the Obama rule unsuccessfully. Then they backed up, successfully revoked that, passed their own rule. As soon as the Trump administration rule was passed, numerous lawsuits were filed. Now President Biden gets elected. And President Biden and his administration said, we're going to try to clear this up. And this was interesting because in 2023, by that point, excuse me, the Sackett case was pending in the United States Supreme Court. So a lot of people said, well, why is President Biden passing a new rule when the United States Supreme Court is going to decide this case? Well, the Biden administration passed a new rule anyway in 2023.
Jesse, if you need to take a glass of go get a glass of water or anything, feel free to do so.
Thank you. Sorry, it figures just when you're doing a webinar, you start getting tickles in your throat. But so the Biden administration went ahead and passed their rule anyway, and it was in May of 2023, I believe. And the Biden administration took the approach that, well, the Obama rule adopted the Kennedy significant nexus. It got challenged, and some courts struck it down. The Trump administration took the approach of let's do the Scalia approach. It has a physically abut. It was challenged, and some courts struck that down. So the Biden administration said, let's combine both. And we'll say if it meets either the significant nexus test or the physically abutting test, then it's jurisdictional. Well, that didn't work to stop the lawsuits. A number of lawsuits were filed challenging the Biden administration rule. And so during this time period, we had, when the Obama rule was passed, for example, for one brief moment, all 50 states about it by the Biden administration. It was challenged, struck down by some states. So at one point, we had about half the states, the Biden rule, about half the states were using the old 1985 rule. And then the Trump administration came in. At one point, we had about half the states Biden rule, half the states Trump rule. And then it became about half the states Trump rule, about half the states were using the old 1985 rule. And then we get President Biden rule. And again, it started to split up in that respect. So in March, the Biden rule took effect in 48 states. But in April, and I am going to take a second here.
No problem.
In April, the Biden rule was blocked in 25 states. So again, we had about half the states were using the Biden rule. About half the states were using the old 1985. Then the Sackett case was decided in May. Right now, just to let you know, we are at a place in time where we have about half the states are using the Biden rule, and about half the states using the old 1985 rule. So the regulatory roller coaster continues. The Sackett case, and this is a case that caused a lot of consternation, a lot of concern across the country. But wait a minute, it was 9-0. Another 9-0 Supreme Court case decision. But it was only 9-0 on two different issues. The first issue was whether the wetland in question was subject to the Clean Water Act. The Sacketts owned a piece of property that had a quote unquote marshy area in one part. Then there was a road, and then a berm, I believe. Then across the road and over the berm was a lake that was navigable. The EPA had said that that was close enough to be adjacent. The court said no. The court said 9-0, that's not an adjacent wetland. More importantly, the court said 9-0. The significant nexus test is not the appropriate test to use to determine whether a wetland is jurisdictional or not. The court then split 5-4 on what the appropriate test should be. And that was the three, what we would call liberal justices, joined by Justice Kavanaugh. The 5 majority justices said they basically adopted Justice Scalia's test. And they said, if a wetland is to be subject to the Clean Water Act, it must have a continuous surface connection, which really means it has to abut. They also said, adopting from Justice Scalia's opinion in Rapanos, that waters of the United States means a relatively permanent body of water connected to a traditional interstate navigable water. So that narrows it down a little bit. We need to have something that we think of as a river. Justice Kavanaugh and the 3 liberal justices said that adjacent basically means in the neighborhood. It can be separated by or something like that. But apparently, under the minority opinion, it cannot be separated by a road, as the Sackett wetland was. So, Sackett gives us some clarity. We do know now that under the Water Act, to be jurisdictional, the wetland has to abut a traditionally navigable water. However, there are lots of questions that still remain. First, let me talk about what the administration did. So in August, without any public notice or comment, and some people have quarreled with that, the Biden administration amended their rule. And what they basically did, and they really released it in a track changes where they went through and everywhere it said substantial nexus, it crossed it out. It also said that adjacent means continuous surface connection. Said that intrastate waters are no longer waters of the United States. However, rule doesn't define relatively permanent, standing, or continuing flowing waters of bodies of water. So some of the questions are: intermittent waters, can they be waters of the United States? Are they relatively permanent? I'm not sure. How about ephemeral streams? Probably not. Are ephemeral streams relatively permanent? Probably not, but it's uncertain. So those lawsuits that were filed against the Biden administration rule, they're still going. They're like the Energizer Bunny. They are still happening, and we're still fighting over that. So where are we now? We don't know what a tributary is. Tributaries of navigable waters are navigable waters, but the court has never agreed on what tributary means. And in fact, the EPA has never defined that. Like I said, intermittent and ephemeral streams, we don't know for sure. It seems like groundwater is not WOTUS because it has to be continually flowing. But I'll talk about that in a second. So really, it's up to state and local governments now, but it always has been. So what I see in the future is some more litigation to try to figure this out. Now let me mention Maui County. I'm going to try to do this pretty quickly, but I think it's important. In 2020, there was a United States Supreme Court decision, which I think expands what the Clean Water Act can cover. And that looks at discharge. You cannot discharge a pollutant into waters of the United States. Here's the question that the court looked at in Maui County. What if the pollutant is not discharged directly into the navigable water, but it's discharged into the groundwater or seeps into the groundwater? The groundwater is hydrologically connected to a navigable water. And so that the pollutant flows with the groundwater and eventually makes it to a navigable water. Is that a discharge that requires a permit? And the courts were split on this. A lot of the cases were coal ash ponds, where we had a coal ash pond, it leached into the groundwater and eventually made it to navigable water. Well, the United States Supreme Court managed to confuse everybody even more. Any of you who know that I like to say the answer is it depends. And so the United States Supreme Court said if a pollutant goes into the groundwater and eventually makes it to a navigable water, you need a permit, it depends. You look at the time it takes for the pollutant to get to the navigable water, the distance, sure, the material it travels through, the extent that the pollutant is diluted, how much pollution enters the water, the manner or area which the pollutant enters the water, and has the pollutant maintained its identity. So we're going to need a lot of expert testimony here. Since the County of Maui case, courts that have considered it are unanimous when they say that, well, this is a really case-by-case decision. We're going to need to have a trial, and we can't really dispose of these cases summarily. Most of the cases have been wastewater cases, where wastewater has made its way into the groundwater and eventually into a navigable. So we've got a lot of uncertainty as to discharge that requires a permit. We still have uncertainty as to what are waters of the United States. So in summary, the state of the federal regulation of wetlands is kind of like this. It's a mess. There's a lot of uncertainty, a lot of things that we're going to have to keep fighting about and keep litigating. So I promised you some good news. Where the good news is, what can state and federal governments do? They can actually do a whole lot. I remember I talked about waters of the United States, and that's a very narrow category. Has to be connected by navigation or commerce of some sort. So very difficult to meet that. Remember, I talked about the 10th Amendment to the United States Constitution. States have all the default powers. Most of the states have defined waters of the state. And when they define waters of the state, they are not limited by the Commerce Clause. So waters of the state include groundwater, surface water, intermittent streams, ephemeral streams, mud puddles. Anything can be waters of the state. And most states have passed pretty broad waters of the state provisions that give them the right to regulate waters wherever they are. And at the local level, lots of local governments are using zoning and subdivision and other authority to regulate wetlands. 34 states have some type of wetlands regulation. Seems like most of the states that do not are inland and often very arid, like Arizona is not on the list, for example. But the majority of our states have some type of wetlands regulation. And here I just put the benefits of wetlands. Most of you know this, but I think it's important that when you craft your state or local regulations, you should put in your prefatory language this and what the benefits of wetlands are. So these state regulations, the first thing I want to talk about is the Coastal Zone Management Act. All of the coastal states fall under the Coastal Zone Management Act. And the framework of the Coastal Zone Management Act basically says that the federal government and the states are going to form a partnership. The federal government's going to provide technical assistance and financial resources. The states are going to do the on-the-ground regulating and planning. Coastal Zone Management Act says if the state comes up with a coastal zone management plan that meets the framework that the federal government sets out, the federal government will provide technical assistance to make that plan and to enforce it. And it has a very unique incentive called consistency. If federal government approves your plan then all federal actions must be consistent with the state plan. It's been very successful. Um, all the coastal states have a coastal management plan. Um, most of these, or all of them, will cover coastal wetlands. Now, also, some states have a shoreline or shoreline zoning model for lakes and rivers. And some of our statewide growth management plans specifically address wetlands. And then there are a minority of states that actually have state laws that are focused directly on wetlands. So those are some of the models. Massachusetts passed the first state regulation of wetlands in 1963. That was before Section 404 of the Clean Water Act. So states have been doing this longer than the federal government. The first inland wetlands law was in Massachusetts in 1965. And these laws at the Massachusetts state level were modeled on local wetlands laws in Massachusetts. So 21 states have laws that regulate coastal wetlands. Only 7 states have laws that focus specifically on inland wetlands. And I think that's a Coastal Zone Management Act, where in a coastal state, you're going to cover coastal wetlands. Covering inland wetlands, there is no equivalent to the Coastal Zone Management Act. So it's more hit and miss. And some of those, like for example, Delaware, it only covers inland wetlands of over 400 acres. The law in Pennsylvania is very highly specialized. Of these 17, 4 of them operate primarily through local controls. And that's Connecticut, Massachusetts, Washington, and Wisconsin. But we can see that there are lots of local controls of wetlands already existing. Now let's focus more on local governments. Again, there are different approaches. Some state laws say, here's expressly when local governments can regulate. Some, on the other hand, give local governments broad discretion in regulating wetlands. Some require state approval, and others have strict criteria for the local programs. 2 examples, in Connecticut, all inland wetlands are subject to municipal regulations. In New York, on the other hand, smaller wetlands are left to the local option, but the state must map wetlands greater than 12.4 acres. Local government can regulate. Now I'm going to talk about zoning and more specific local regulation. And if you know me, you know I've got to say Dylan's rule, and I've got to talk about authority. But again, I've got good news for you. The courts have said that local governments have authority to take wetlands considerations into account on its own. And a lot of what I see out there ties wetlands regulations to floodplain regulation. Floodplain regulation at the local level is common. We don't know exactly how many local governments are regulating floodplains, but it's a lot. Wetlands regulations by local governments is less common, but it still prevents. Half of the states specifically say in their enabling authority floodplains. I couldn't find any state enabling authority for wetland for zoning that specifically said wetlands. However, no court has ever struck down a wetlands regulation by a local government because of lack of enabling authority. Um, and some courts that have upheld the wetlands regulation at the local level have pointed to the standard state enabling act language that says that zoning is supposed to promote the health, safety, welfare. Zoning looks at the most appropriate use of land in the location of buildings. So much like in our zoning ordinance, where we say, well, you can't build in the floodplain, or if you build in the floodplain, there are specific restrictions and requirements. It appears that local governments can do much the same thing with wetlands and that they have authority to do that. What different approaches are local governments using with respect to regulate wetlands under their zoning ordinance? One common approach is to use an overlay zone. Most of you are probably familiar with overlays. You have your zoning ordinance that lays out the districts, and then you take a wetlands overlay and put it on top of that, that basically tracks the wetlands in your jurisdiction. Now, one thing that I thought about with respect to this, I don't know GIS. I'm not a mapper, but I think for local governments to be able to regulate wetlands, there's going to have to be some mapping of those wetlands. And I think in some areas that might be difficult. It might be expensive, but I think there has to be some mapping done to back up, especially if you're going to do an overlay zone. Where are you going to put that? Another approach is to require a conditional use permit for development in the wetland. Uh, and you can have your additional requirements, your supplemental regulations. But just like all conditional use permits, you should be really careful to lay out those requirements and make sure that you're clear and that it's not a case by case, but you're applying clear regulations in every situation. Another approach is cluster zoning, and I think some of you probably use that for floodplains or for other types of sensitive environmental areas, where you map out where are the wetlands, where are the floodplains, and you try to group the structures on areas of the parcel. So that's another approach that is being used and could be used for wetlands. Um, and I'll kind of combine things on this one. Um, when your wet regulations at the local level are challenged, that's most likely going to be a taking challenge. The vast majority of these takings challenges to floodplain regulations and to wetlands regulations have not prevailed. The plaintiff has not prevailed in these. It's very difficult to prove a takings in this context. However, you may have a situation where a landowner's entire parcel, where 90% of the parcel is covered by wetlands or floodplains. If you tell that landowner they can't build anything, that could be a taking. So another approach that we use most often in farmland, but I think would be appropriate in instances for wetlands, would be to set up a transfer of development rights program where you say you cannot build in this wetland area. However, we will give you some development rights and you can transfer them to people who are in other areas of your jurisdiction that do not have wetlands or other sensitive areas. And they can be used to develop those areas more intensely. And so these are all tools that most of you are very familiar with. You've used them in other contexts, and I think they're applicable for wetlands. So that's my good news for today, is that even though I would argue that Section 404 in the Clean Water Act is a mess when it comes to regulating wetlands. And that's because going back to the very beginning of my presentation, Congress is shackled by the Commerce Clause. And so they can't pass a regulation that says, let's protect wetlands. At the state and local level, you can. And I think most or all of you already have that authority. Of course, for each particular locale, you should look at your state statutes and state regulations. But I think most of you, if not all of you, have authority to protect wetlands at the local level. You certainly have the right to do it at the state level, and that can fill any gaps that may be there after Sackett. So now I'm happy to answer any questions.
And I will say, we have a question from Laura Belsh in the chat, but I just wanted to first thank you so much, Jesse. We've received a few comments in the chat speaking to how great of a presentation it's been. And a reminder to our attendees to please submit your questions through the Q&A box as opposed to the chat box. That will just help us keep track of all the questions. So Laura is asking, any insights on how jurisdictions are dealing with permitting linear projects like local roads?
That's a great question, Laura. And I think the linear projects are very problematic. And actually, I don't throw any shade on any Department of Transportation people that might be on the webinar. But the anecdotal evidence, sometimes even statistical evidence that we have indicates that state departments of transportation fill more wetlands than any other group. And so, unfortunately, I don't know how they are handling this. I know that New Jersey has a provision that's similar to the coastal zone, that if adjoining jurisdictions coordinate their planning, that the state will be based on the local planning regulation, the local zoning. So I think that would probably be a fruitful area to look, is that how you work with your state to say, let's collaborate, say that if the local government uh, passes regulations that are in line with state uh, expectations, um, that the state will not ruin those plans by putting a road through the wetlands or something like that. So that's a great question. I'll have a better answer.
And I see a logistical question in the chat as well, in regards to the recording. And yes, the recording again will be posted on the MAPC YouTube channel, which the link is just up above in the chat. And I know that Jesse and Jared both are comfortable if you reach out with any questions after today's webinar as well. All of that information with their contact information, with the link to the recording, will be sent out in a follow-up email to all attendees. And again, please submit your questions through the Q&A box if you have them at this time. We have 30 more minutes, so we welcome discussion.
I believe there are no questions about waters of the United States.
Oh, it looks like an attendee may have raised their hand. Oh, they took it down, so maybe not. You are also able to raise your hand to request to be unmuted as well. And Jared, feel free to hop on too if you have any additional insights to add. Thank you, Harrison. Jesse, do you have any other points that you think you should leave the attendees with, or?
Well, I'll just say that for quite a while, I've been advocating that a coastal management act type model be extended from the coast to all over the place. And I think that would be a logical way to encourage and support state and local governments in regulating wetlands. Um, Suzanne has her hand up. Just one more thing, but I think if the federal government could give states financial and technical assistance and encourage them to pass wetland regulations, I think that would really expand the scope of state local regulation. And I think that's the way to go. I think we've wasted a lot of time at the federal, in my opinion. Suzanne had a question.
Yeah, I do. While all this was going on in 2022 and 2023, it was changing back and forth from ephemeral being considered jurisdictional. We were getting permits on projects. So what if we got a permit and for an ephemeral project, they haven't constructed it yet. How does all this affect that as far as at the federal level?
If I'm understanding you right, you're asking that you got a permit because at that particular time you got a permit or you thought you were required to get a permit.
Yeah, it was,
So
well,
you
originally,
got a permit
right,
and now it looks like you didn't need a permit.
right.
What now? And I think what you would have to do is go back to the agency and say, we don't really need a permit for this, and we want to go ahead and confirm that you and basically have them withdraw the permit. I think that's what you would have to do.
Now, will the state also withdraw the 401?
You have to talk to the state about that too. I mean, that's a good point. I think the messiness of the regulations changing constantly is going to cause some mess at the state and federal level as far as these permits have already been granted. I mean, the permit holder could just say, well, in my opinion, I don't need this permit, I'm going to abide by it anymore.
Right,
But that's a very aggressive approach, and you risk have state or federal government come after you for that. So if I was involved, I would say get something in writing from the state and federal agencies saying that you're no longer subject to the permit conditions.
yeah, now the state also has another permit that applies that's not tied to section 404, which is probably equally as strict as the 401, but like
Yeah,
you
and
were
that's the
talking about. So it's just interesting to see how it would affect some of those existing permits with pending projects.
Yeah, as you know from getting permits for these things, sometimes you have to get a federal permit, or more state permits, and one or more local permits. You might have a whole bunch of permits out there.
Right. That's a good presentation. Thank you.
Thank you.
And we have had a few more questions come in. Roberta is asking, do you have an opinion on Kennedy versus Scalia opinion, Obama rule versus Biden rule?
I would say here is my opinion, I guess, or what I would say from a legal point of view. The advantage to the Scalia rule is that it's a relatively clear rule, bit of certainty. The issue that I have with the Kennedy substantial nexus test is I call it the circle of life. You could argue that anything has a significant nexus to navigable water. And in fact, there is a Hawaii case that said that groundwater has a significant nexus to navigable water. Therefore, discharges into groundwater, you need a 404 permit. Um, so I think there's a lot more uncertainty with the Kennedy rule. I also think, and you might have already gleaned this, but I've said for a long time, why are we fighting over this at the federal level? The federal government is not really well suited to permit this. Let's allow the states and the local governments to do it. But again, let's do something like the Coastal Zone Management Act, where the federal government says, hey, if you regulate wetlands the way we want you to, we will give you money and we will give you technical assistance. That way we don't have to worry about the Commerce Clause and what's navigable and all of that. We're trying to fit a square peg into a round hole on 404, and it's just not working. We spent a lot of money on attorneys fighting over this. I would rather spend money protecting the wetlands.
Thank you, Jesse. And we have a few more in the chat. Megan Lehman or Lemon, excuse me for mispronouncing the last name, has anyone attempted to demonstrate underground connections between surface waters and wetlands to demonstrate they are in fact one system? I'm thinking dye tests like are used in water or sewer systems.
Yes, and in fact, I mean, I can make this a 30-hour webinar. That first case at Riverside Bayview Homes in 1985, the wetland actually connected to the lake through the underground water system. And the court seemed to think that was important at the time, but now it's been forgotten. And now, under the Scalia test, and so going back to the prior question, I would say that the Scalia case misses the boat with respect to the fact that it doesn't surface connection. You're absolutely right. It groundwater connection. And there have been cases looking at that, and people have done that. But I think at this point, where we are with the federal regulation, we're going to have to, if we're going to pursue that any further, it's going to have to be at the state level.
And then another question, actually, this one was more of just commentary, I believe. Joseph Grubbs, like many people have commented, excellent presentation. He had the opportunity to work on the TDR program in Hendry County, Florida, as well as working with SFWMD on developing a GIS model for cumulative impact assessments. Would love to connect and we'll follow up with you after the presentation. And a few more comments coming in. Just thanking you for a great presentation, Jesse. And then there are a few more coming in the Q&A. So let's see. Roberta has another question. Any suggestions for a community who stood up to industrial production plant and fought the toxicity, of being in their neighborhood but lost, finding out now that the chemical drying ponds may not have been built to correct specifications? So we may have leaking into the groundwater now.
Yeah, Roberta, I think that's spot on the Maui County case. So I think there's an opportunity to say that if you have these chemical drying ponds where the chemicals are leaked to the groundwater, I mean, that would come under the Safe Drinking Water Act, which is state law for the most part. But if you can show that those chemicals make their way to navigable water, then you can say you need to get a Section 404 permit under the Clean Water Act. So I think, again, a lot of it comes down to science and dot tracing and the like. But if you can show it eventually makes its way to some navigable water, that possibly come under the Maui County case. And I see where Suzanne has a question. Do you foresee any way the federal government can regulate inland wetlands and surface water protection without tying it to interstate commerce? And that it might be an easy question because I think the answer no. I think that's the only authority the federal government has. They have tried with things like TMDLs and things like that, and it hasn't been very successful. And the United States Supreme Court has, on several occasions, said federal government can't infringe on the state authority to regulate land use. And so you get too far, like TMDLs is definitely a land use issue. And a lot of regulating inland wetlands, I think, is a land use issue. So I think the federal government is trying to do this with both hands tied behind their backs. And I think it's going to be continuing to be difficult. That's why I think they should partner with the states and the local governments and provide funding, technical assistance to encourage local governments and state governments to do more. And Suzanne, do you have something additional?
No, it's just yeah, it's interesting. But I think you're right. It is gonna fall to the states for those areas, those gray areas. And like you said, they are already doing a lot, to protect their waters and wetlands.
And Sean, I never say never. The question is, the federal government is never allowed to infringe on states' rights to regulate land use correctly. You heard it mostly correctly. The court on several occasions have been very protective of the state and local government's right to regulate land use. So while I would never say never, I think that the courts are vigilant on that. And in the states, I'm also seeing increasingly states and local governments filing amicus briefs in the United States Supreme Court and in other courts saying, whoa, federal government, so states have been diligent in trying to protect state authority. And I think courts have been mostly persuaded by that.
Yeah,
Joseph, oh, go ahead.
I guess there's still other laws like, that kind of feed into protecting waters, like the Endangered Species Act and some of the other protective laws. So
Yeah, and there have been arguments in those cases about infringing on the state authority. And Joseph asked about examples of public-private partnerships for wetlands protections. I can't give any examples off the top of my head, but I know there are some land trusts out there that are putting conservation easements on property or buying property to protect wetlands. So I imagine that there is, and Jillian might have something to add on that. Or is that just you marking that question, Jillian?
I'm sorry, I was answering another question in the chat for Robert Alter, so I'm sorry I missed your
Okay.
question, Jesse. Go ahead.
No, I don't know of anything specifically, Joseph, but I would imagine that there are, but I can't give you any specific examples.
And I'll just pop in a logistical answer to a question here. I saw that we had a comment that this should be approved for law CM credits, and it is. So I'm going to go ahead and copy and paste the CM information again to everyone because it was certified for mandatory law credit. And also, Robert, I see your other question regarding the YouTube page, and I will be sharing that again in the chat in right about now.
Yep, it will be up in our YouTube in a few days, Jillian, or maybe next week.
Well, yeah, tomorrow's Friday, and we're
Oh
hoping
yeah, it is Thursday.
we're hoping to be rolling out APA Virginia registration in the coming days. So I would say mid to late next week, but you all attendees will be getting a notification in your inboxes with all of those links that we mentioned.
And I apologize for the dry throat. It's not bothering me now, but we're done now.
Only when presenting.
Yeah.
That's how it goes. Well, thank you so much, Jesse. I mean, I think everybody found this incredibly valuable. So we appreciate your expertise as usual. And everybody keep your eyes peeled on your inboxes for that information. Thank you for joining.
Thanks, everybody.